Thank you so much for coming. This is our fourth McLean and Me. We're doing it every month as an educational series, and we're looking to be a resource for the community, our residents, and everybody. So one of the things that you'll see is a survey. If you could fill that out, we're looking for ideas for the next McLean and Me series. So that would be really helpful. Today's McLean and Me is expert advice on legal and medical planning. And what we have Attorney Bickford, we have Dr. Polikas, and Janet Collins. We're going to start the evening with Attorney George Bickford, General.
I get a raise here.
And as we go through, I'll read you everybody's bio, but I'm going to start with Attorney Bickford.
You can keep it short.
Okay.
You don't have to do the whole thing.
All right. Attorney Bickford began his practice at Neighborhood Legal Services, where he was the director of Senior Citizens Law Project for North and Central Connecticut as a pioneer in the practice of elder law in Connecticut. He is also a member of the National Academy of Elder Law Attorneys and served as the co-chair of Elder Law Section of the Harford County Bar Association. Attorney Bickford is a graduate of Harvard and the UConn School of Law. And I'm going to pass this over to you so you can take it.
Pass the mic. Thank you very much. Thank you. Hi, folks. First of all, I want to thank Heather Ryan for inviting me to come and speak to you folks. I've been here a number of times at McLean, but not in this new facility, so I'm very impressed. They did a great job. And what I really like, my dad was in the construction business, is that most new construction is, basically plasterboard, sheetrock. I love the wood. This is just beautiful. So he did a good job for the folks here. Now, what I want to talk to you folks about tonight is a couple of things. Number one, and I don't have a lot of time, we got 20 minutes, so I'm not going to waste time on this, and I'm going to go pretty quick. So when they ask you to do your evaluations at the end, don't say Bickford talks too fast, okay? Because I'm doing it for your benefit. First of all, I want to talk about planning. It's very important for everybody. I don't care if you're 30 or 90, ill or well, everybody should have certain things in place. And the first of those items is a power of attorney. You should have somebody, a trusted individual, to be your attorney in fact under a power of attorney. This is so somebody can sign for you if you're unable to do so for yourself. For example, if I have a husband and wife, I would recommend a husband named wife named husband, and each of them name a trusted individual as a backup. And that could be their children, or somebody else if they don't have kids, a niece, nephew, brother, sister, generally somebody younger than you who can take care of things if you become incapacitated. The power of attorney should include financial affairs, and it should be customized because there's many things that are not in the power of attorney unless you actually put them in. For example, the old statute didn't have anything about retirement funds. No, they've added that to the statute now, so you'll see most of the new powers of attorney, anything since 2016, will have language about dealing with retirement funds, retirement plans, IRAs, 401ks. In addition, if you want your spouse or your kids to be able to use the power of attorney to transfer assets in the event of your incapacity, it's very important that the powers of attorney have gifting authority, the ability to transfer assets for $0. So for example, I have a power of attorney naming my wife, she has a power of attorney naming me, and each of us have given power of attorney to 2 of our kids, so we have backups. 2 trusted children that I know work well together. They don't both have to sign, it can be either or, what's called a several power. And the power of attorney I've given my wife gives her a blanket authority to handle all my financial transactions if I'm unable to do so for myself. It also allows her to make gifts on my behalf, including gifts to herself. Now the reason for this is that if I become incapacitated, and if I were to need long-term care, I want my spouse to be able to use that power of attorney, if I can't sign, to be able to transfer assets to her to protect them. Now we're going to talk about long-term care after we talk about planning, and we're going to talk about asset protection for a well spouse or for children. So those powers of attorney should have gifting authority. I have no problem with an unlimited gifting power in husband to wife. Now the power of attorney that we give as a backup to the children should also have gifting authority, but you can limit that gifting authority so they can't give away the farm willy-nilly, okay? What we want them to be able to do is to make gifts and transfer assets in accordance with your specific written instructions, and that will be number 2. We're going to get to that. So the powers of attorney should include all kinds of financial affairs. They should be durable, which means if I become incapacitated, they're still good. Don't get nervous and go home and look at your power of attorney and it doesn't say durable on it, because durability is a concept. And many powers of attorney don't say durable power of attorney, but there should be language in the power of attorney saying that this power of attorney will not be affected by my subsequent disability or incompetence, which means if I become incapacitated, the power of attorney is still good. That's what I want it for, in case something happens to me. Secondly, the power of attorney should have blanket authority to handle all kinds of financial transactions, including retirement plans. So if you did a power of attorney before 2016, you probably should talk to your planner, your attorney, hopefully an elder law specialist, who can assist you in updating them. The third item is making sure there's gifting authority if you want to be able to protect assets in case of a long-term care need. The second item in that list is the instructions. I have a letter to my wife. She has a letter to me, and they're signed, witnessed, and notarized. And these letters tell us, each other, what to do about protecting assets in the event that one of us becomes incapacitated and requires long-term care. And we're going to talk about asset protection when I talk about long-term care in a minute. In addition, we have letters to the kids telling them what to do, our backups, my son and daughter, telling them what to do about protecting assets should the second one of us need long-term care. Because remember, if something happens to me, my wife controls. If something happens to her, I take care of business. But if something happens to the second one of us, we want the kids to be able to be in a position to do whatever's necessary to preserve and protect as much of our estate as is legally possible. So those are what those instructions are about. They're very technical legal letters. They're very detailed. The one to the kids is generally about 4 pages long, and it covers all kinds of legal consequences and gives them the authority to act, okay, in conjunction with the power of attorney. The third item on our list, and if you look at the things that we've given you, I have 3 separate handouts. The yellow one says estate planning basics for seniors. You don't need to look at it now, but this covers those things: the power of attorney, the living will, last will and testament, and also it doesn't talk about the instruction letters, but that's why I'm talking about them now. The so-called living will is the third item on our list. First is the power of attorney, second is the instruction letters, third is the so-called living will. And I say so-called because, as Dr. Please well knows, living will is a layman's term. It's a colloquial term. It's a euphemism. Because it's not about living, it's about dying. And it's not a will because it has nothing to do with property. What it is usually called a declaration and directive to physicians, or sometimes referred to as healthcare instructions. It should include in it, or there should be a separate document if it's not included in the living will, euphemistically living will, declaration and directive, should also have the appointment of a healthcare representative. Now, you may have heard people call that a healthcare proxy or healthcare surrogate. Well, it depends on what state you're in. Massachusetts, they call it a healthcare proxy. New York, they call it a healthcare surrogate. Connecticut calls it a healthcare representative. That's the person who is going to be able to speak for you to your doctors, to the hospitals, if you are unable to speak for yourself. Now, the living will would basically say that there are certain circumstances under which you do not wish to be kept alive by artificial life support systems if you are dying. And we try to be extremely precise in our language to make it clear that it's only if there's no hope of my recovery. If I'm going to die, no matter what they do, within a matter of days to weeks, if I'm in the end stages of a terminal illness, or number 2, if I'm in a permanent coma, irreversible, or number 3, a persistent vegetative state, which as a result of a brain trauma, my living will basically tells my doctors that I do not want artificial life support systems to be utilized if they would only serve to prolong the dying process. And then I have a list of items I don't want them to do: CPR, mechanical breathing apparatus, artificial nutrition and hydration. And then those were the 3 items in the original statute, but we've expanded that. And our list includes 10 items, which would include such things as major surgery, minor surgery, chemotherapy, kidney dialysis, invasive testing. Those are all on the list. Now you might say, well, why wouldn't I want those things? You don't want them if there's no hope of your recovery, if they're only going to prolong the dying process. And I tell my clients, if you have a living will and there's a chance of saving you, this is irrelevant. They're going to do whatever's on that list to save your life, to make sure that you get the quality of care that you need, as determined by your healthcare representative and your physician, okay? In addition, that document should also either include in that document or a separate document the appointment of a healthcare representative. Now, my reading of the statute says you may pick a or an healthcare representative. So it's really not a committee. You name your spouse. If your spouse can't do it, you name one of the kids as a backup. Now, my son's a doctor, so I've named my wife as my healthcare representative. And I know if there's a question, she'll talk to my son, okay, because of his expertise. And I've named my son as backup in case my wife can't do it for me. And then I have my daughter as backup to him if he can't do it. These things should be signed, witnessed by 2 people, and notarized. They should be executed in the same manner that somebody would execute a will. In addition to that, everybody, all of you, I don't care if you're 30 or 90, ill or well, like I said, if you're rich or poor, you should have a will. Now, I had a client just the other day said, well, everything we have is joint or has a beneficiary. Why do I need a will? Well, if everything's joint or has a beneficiary, those are not going to go through probate. They're not going to go through the will. But you want the will just in case. Because you'd be surprised how many people I've had who come in and say, well, everything's joint or has a beneficiary, and then we find out that dad had this retirement fund with no beneficiary designated. Which means we had to go to the probate court to get it released to his wife. Now, who gets the retirement account if there's no beneficiary? Whoever's named in the will. So the will should say who gets what, and it should say it goes to my wife. If she's not alive, it goes to my kids. If my kids aren't alive, it goes to their children. The will should also have a provision in it saying if it does go to my grandkids because my son or daughter has died before me, then we want it to be held in trust for them until they reach a certain age. I generally, a lot of people say 18. No, they're just starting college at 18. 21, they're still in the middle of college. 22, they might still be in their senior year. I recommend 23 as a minimum because we don't want the kid quitting school and running off to Aruba just because grandpa or grandma left them some money, okay? And in your will, you also name an executor who does what the will says, and you also name a trustee, and the executor can be the trustee for the grandkids. So I've named my wife as executor. I've named my son Ross as the backup executor and trustee, so he would be trustee for his sister's kids if she died before me. And I've named my daughter as executor and trustee, and she would be trustee for my son Ross's kids if he died before me. So this is all spelled out in the will. Now people say to me, well, shouldn't we have a trust? Please understand something. There's a lot of companies out there and law firms that try to sell you a trust. I'm not saying a trust is a bad thing, but it's not necessary in most cases. If you have everything joint or with a beneficiary, we don't need a trust, okay? However, if I get a single individual in my office, somebody who's widowed, divorced, or single, and owns assets, it might be a good idea to do a trust because a will goes through probate. And if you'd like to avoid the probate process, there's 3 ways to avoid probate. Number 1, joint assets. Number 2, assets with a beneficiary designation. Or number 3, assets in trust. The trust does not go through the probate court, okay? So there are times when that's necessary. There's also other reasons to do a trust, but if you're under $5.8 million, or between you and your husband or your wife, you're under $11.6 million, there's gonna be no estate taxes. So we don't need to do special trust to avoid estate taxes in Connecticut if you're under 5.8 million as a single individual or 11.6 as a couple, okay? But it might be advisable to do it if I have a child with special needs. I might want to do a special needs trust. Or if I have a child who has emotional or psychiatric or drug-related issues, I might want to have a supplemental and luxury needs trust for that child so somebody else can manage it. So if one of my kids was incapacitated, I would set up a trust and I could put assets in that trust either through my will or during my lifetime and name somebody as trustee. I could be the trustee during my lifetime and I would have my son or my daughter as trustee after I'm gone. Or my wife first, then the others. So there are reasons to do that, but it's not necessary for everybody, okay? Now, I don't have a lot of time, so I just want to get a little bit into long-term care. Now, if you take a look, there were 2 things here that I gave you, and one of them is the pink one, or salmon, I guess you'd call it. It says, why should you consult an elder law attorney on Title 19 Medicaid issues? Medicaid is a very complex legal system. You know, do you do your own tax return? Usually not. If you have a complex situation, you go to an accountant. Okay, if I have a medical problem, I go to a doctor, okay? And if you're gonna be doing something like legal documents, you don't do them online, you consult with an elder law specialist. And if you need long-term care, you should be consulting with an elder law specialist. So you can read that and it tells you why. The third one is a Medicaid reference for caregivers. Now this is all about what Medicaid rules are and about asset protection, what we can do, what we can't do. So for example, if I want to apply for Medicaid, if I'm a single individual, I can only have $1,600 in order to qualify for Medicaid. Now if I'm a married individual, my wife gets to keep, if I need long-term care, my wife gets to keep the home, 100% free and clear, one car, any dollar value, so she can go out and buy the Lamborghini or the Mercedes, whatever she wants. She can also keep 50% of tangible personal property, our stuff. She also gets to keep her income, and she also gets to keep 50% of the remaining assets. But there's a minimum and a maximum. The minimum is $50,000, and the maximum is $148,620. Now, the reason for the funny number is those numbers are indexed with inflation, and they go up every year. And this is the new number as of January 1st, 2023. It's $148,620. It's in your handouts, okay? So if I get somebody, let's say this client comes to see me and she has $348,000 between her and her husband, plus the house and the car and the personal property. I'm going to tell her she gets to keep the house, the car, the personal property, her income, and $148,000. She goes, but I have $348,000. What do I do with the other $200,000? Well, if she doesn't do something with it, she's going to have to spend it on her husband's care. Okay? It's called a spend down. You may have heard that term. But the spend down gives us plenty of options. She can fix up the house. She can pay off an existing mortgage or a home equity loan. She can pay off any debt, including credit cards or whatever. She can also fix up the house. She can also trade in the car and buy the Lamborghini. Okay, I'm gonna buy a Jaguar or something now, my wife, so don't worry about it. I think it's a waste of money, but you know, if I have to spend the money, I'm buying the Jag. She can also purchase clothing, furniture, appliances, and household goods because the tangible personal property is excluded and not counted. She can also keep $148,000, but the other $200,000, and by the way, she can also purchase prepaid funerals, burial plots, and headstones, and that's all spelled out in this flyer. And you can read that at your leisure. It talks about what you can and can't do. But if she saw me with $348,000, I told her she can only keep $148,000. She's got to either spend the $200,000 or, it's a neat little trick, she can purchase what is called a SPIA. Now that's an acronym. It's capital letters SPIA, and that means single premium immediate annuity. So she can purchase an annuity, and the annuity would take an otherwise countable asset and convert it into a stream of income for my wife. And her income is not counted. So we've taken something that would otherwise have to be spent down, put it into an annuity that gives my wife income for life or for a term certain for a period of years, and the state doesn't count that. Now there's certain requirements for that annuity, so you just don't want to go out and buy any annuity. It has to be a Medicaid-friendly annuity, and what that means is there's only certain companies that know how to do this. One of them is Nationwide. I think Northwest Mutual is another one, I'm not sure. But I have a broker that I deal with, and we send clients to him, and he helps them to set up these annuities. There's 4 conditions on the annuity for it not to be countable and not to be considered a transfer of assets, okay? And we'll get to that in a minute. It has to be irrevocable, which means mom can't change her mind 6 months later and say, I want my lump sum back. She can't do that, because if she could, the state would say, go get it and use it to pay for your husband's care. Number 2, it must be non-assignable, which means she can't sell the annuity. You've seen those companies late at night. Hi, I'm with Universal Funding, and we'll buy anything. We'll buy your life insurance policies. We'll buy your mortgage. Are you tired of getting monthly payments? Do you like a lump sum? We'll buy your annuity. This has to say that the annuity is non-transferable. Thirdly, it has to be actuarially viable. So in other words, if my wife has an 8.6-year life expectancy, she can't be buying a 10-year annuity. It has to be arguably considered to be payable over her life expectancy. So if her life expectancy is 8.6 years, she buys a 5-year annuity or a 3-year annuity. That's the shortest period that I'll sell. So what happens is once she's converted that extra $200,000 to the annuity, she can apply for Medicaid for her husband, and Medicaid will pay for her husband's care, okay? In addition, there's one thing you need to be very careful about, and I think I've used up my 20 minutes.
No, you're good.
Okay, a couple minutes max, because we started at 6:02.
Yeah.
Whatever. Transfers of assets. Everybody comes into my office and says, I want to give this to my kids. I don't want to see this have to go to a nursing home. I want to give it away. Well, there's a 5-year look back on asset transfers. And let me explain to you very simply what that means. It means if I transfer an asset for less than fair market value, in other words, I don't get fair market value in return for the transfer, I make a gift, okay? So I give money to my kids, or I transfer my house to my kids. If I apply for Medicaid within 5 years of the date of the transfer, I will be disqualified. Now, on the other hand, if I give it away and I go 5 years in 1 day, then I can apply for Medicaid and that transfer will not affect my eligibility. But I had a client in my office today, and her mother had transferred to her in 2021 about $235,000, which would disqualify her mother for about, I'm trying to figure it out, about 16 or 17 months from Title 19, which means if she applied for Medicaid for her mom, when mom runs out of money, out of her own money, then mom would be disqualified from Medicaid and the daughter would have to give that money back to mom to pay for her care. So that's why if you're going to be making asset transfers, you want to talk to an elder law specialist. You want to make sure you do it properly. You want to make sure the kids understand that if we don't make the 5 years, this may have to go back to mom, okay? But you got to be careful on asset transfers. Now, there are certain transfers that are not penalized. I can transfer my home without a penalty or a waiting period to my spouse. So the first thing I do when I get a husband and wife, if the husband's going to the nursing home, we put the house in the wife's name. Is that going to cause a problem with Medicaid? No, because the home is protected for the community spouse, 100%. Number two, I can transfer my home to a minor child. Now, many of you might say, you know, we're seniors, how many of us have minor children? My minor child, not somebody else's minor child. Well, minor child under federal law means under the age of 21. So it's possible you have somebody under the age of 21 and they're still a senior. Remember, there's a famous law school case of the fertile octogenarian. So it's still possible, okay? And of course, I've had situations where an elder gentleman married a younger woman and they had kids. He ends up in the nursing home. They've got kids under the age of 21. And if we want to protect assets, we can protect them for that minor child. You can also transfer the home property to a disabled or legally blind child. And of course, people say to me, okay, fine, if the kid's disabled, I'm receiving Social Security disability, I can transfer these assets to them with impunity and still qualify for Medicaid. But what if the child is disabled to the point where they can't manage these things? We can also transfer them to a special needs trust for the benefit of the disabled child. We can also transfer a home property, and by the way, you can transfer assets of any type, not just a home, to a disabled child or to a trust for the disabled child. In addition, I can also transfer my home property to my brother or sister who is a co-owner of the property, okay? In other words, the law says that if my sister has an equity interest in the home and she has resided in that home at least 1 year immediately preceding my placement, I can transfer that home into her name without a penalty, okay? I can also transfer it to a caregiver child. And the caregiver exception says that if one of my kids moves home and takes care of me, or if I move in with my son, the doctor up in New Hampshire, and he takes care of me and keeps me out of a nursing home for 2 years, now my doctor would have to have his file documented saying that I couldn't live alone, I need 24/7 care and supervision, and I'm living with my son, or he's living with me. The rules say that if my son lives with me, I can transfer my home to him without a penalty or waiting period under Medicaid, as long as he keeps me out of a nursing home for 2 years. Now, what if I'm living in his home and I don't have a home? I can transfer as much as $337,000 to my caregiver if we make the 2 years. So there's a 2-year threshold on those rules, okay? So you gotta understand there's lots of subtleties in the Medicaid law. I once did a talk down for the Connecticut Society of Certified Public Accountants, CSCPA, and they had me come and talk to them, and they said, Mr. Bicker's going to talk to us about the second most misunderstood law in the United States. And I said, second? And she says, yeah, the transfer of assets rules. I said, okay. And I said, what's the first most misunderstood rule? He goes, the gift tax laws. Because tax law is extremely confusing. So is the Medicaid law. So you need an expert to help you. I hope I've got you in the right position where you know what to do. If you need help, seek it out, okay? And it's very important. Do your planning first. Get those things in place while you're well. Don't wait until there's a crisis, because then it may be too late. And if I don't have a durable power of attorney in place and I become incapacitated and I can't sign for myself, my wife would have to go to the probate court to ask to become conservator. I don't want my life to become an open book for the probate court. I want my wife to be able to handle my affairs without the oversight of a court, okay? So think first, do your planning, get an elder law specialist, and then if you're considering protection of assets, talk to that elder law specialist about what we can do to protect assets. So thank you much. Are we on questions now, or when we all finish?
Yeah, when we all finish.
Fine, when we finish, you can ask questions, and we'll repeat them and answer them for you. Yes, sir.
On the appointing power of attorneys,
Yes, sir.
let's say the elder person, in good faith, appoints one of the kids to be so, or two of the kids to be so, but then those kids change over time.
You can revoke the power of
For all
attorney.
kinds of reasons.
Right.
And
He
so
said, what if you
is
name
there-
somebody power of
Is
attorney?
there an oversight mechanism?
Well, the probate court is always an
Somebody
oversight
challenge
mechanism.
that?
Let me answer your question.
Based on competency.
The probate court always has jurisdiction over powers of attorney. In other words, if I think my brother is not handling my mother's affairs properly, and I think that he's taking advantage of her in violation of his fiduciary duty, I can go to the probate court and ask for an accounting. And the court can approve or disapprove of what my brother has done, okay? So there is oversight, but you'd have to petition the probate court for a hearing. That's why I tell people, when you name a trusted, responsible child that you know is not gonna be a problem. But if your son starts acting a little squirrely on you, revoke the power of attorney, okay? Cancel it. You'd have an attorney do that, okay? Right, so save your questions for when we finish, okay, guys?
Thank you so much. And that's one of the reasons, we don't want to be super strict like that on the time, but we do want to make sure that we save enough time at the end for questions. And I told the panel, I think this is going to be one with a lot of questions.
Probably.
So, thank you very much. Now we're going to go to Dr. Wayne Polikas. Dr. Wayne Polikas is a member of the Prime Health, the Prime Health team, I'm sorry.
Prime Healthcare.
Prime Healthcare. An associate clinical professor at UConn Medical School and the medical director at McLean, overseeing the care of post-acute patients and long-term care residents. His specialties include internal medicine, geriatric assessments, dementia, Alzheimer's, and comprehensive long-term care plans. Dr. Polikas is a member of the Connecticut State Medical Society and the Medical Directors Association. He is a graduate of Brown University and the UConn School of Medicine.
Thank you. Is this working okay like this? Can you hear me okay? I'm sorry.
Okay.
A little louder.
You made it put it closer, yeah?
Yeah,
That's
probably have to do it like this, right? Yeah. Okay. Well, thank you. One of the biggest challenges I see is going after an experienced lawyer in a conversation, so I'll do my best at this. And, you know, I talked with the folks here and they suggested I try and go over a couple of subjects. I was just going to start this by talking about how things have changed. If I assume a lot of the folks in this room entered adulthood in their 50s and 60s, you know, how did you interact with medicine? Well, you had almost always a male doctor in a solo practice that you would go see, who treated you when you were sick. Probably did not do a lot in preventive care, short of saying, you shouldn't smoke those cigarettes, or you try to die, or, you know, whatever. That doctor would do virtually all of your care, short of if you needed a surgeon, say. They would order your tests, they'd order your medicines. If you had a problem, they would help you out. If you're trying to coordinate care, I need some care somewhere else, they would call if there were problems. You'd often call there, and they often usually probably had someone who worked in the office who was just this godsend and did all this work for the doctor. You paid in cash to the doctor. You know, insurance only got involved if you got hospitalized, if you got in a car accident. It was catastrophic care. And, you know, when it came to advice, you listened to your doctor because you weren't being bombarded all the time, you know, watching TV and being told to buy this or buy that or buy others. I mean, personally, I get fascinated when I watch TV and there are ads talking about what type of third-generation chemotherapy you should take for breast cancer. I wouldn't tell anyone that. And that's very specialized work. Yet, you know, you sit there and watch a football game and they're going to tell you about these things. So this guy back in the 1950s and 1960s, this is probably the only crowd who would remember what Dr. Kildare looks like. That was your model. Okay. So, in the interim, we have Medicare happened in 1965, I think.
Yeah, 68 actually.
Somewhere around there. In the 80s, they developed the concept of health maintenance organizations, HMOs. We now have independent physician associations, IPAs, we have ACOs, accountable care associations, which are now the things you have in the 2000s, and you have SINs. You always had SINs, but SINs, clinically integrated networks. All these acronyms have popped up. So what's happened? Now, this letter soup takes care of you. They're physicians, but they're also osteopaths, and if you ask and say, well, they're really kind of doctors, just a very slightly different path. But now you have these physician extenders, you have APRNs, you have PAs, and when you call looking for help, you don't know, it's not, you're gonna see Dr. Bickford, you're gonna see, well, someone will see you, who? Well, it'll be this whole collection of folks. I'll argue almost to an extreme, and especially when you're talking to a population of folks who have lived 70, 80 years, 90 years. I'll smile and say you are the examples of how preventive care works. You got there. But when you see your healthcare provider, they're going to talk about best practices and preventive care, and we'll go through laundry lists that last forever. Check marks, probably all of you or some of you have had the experience of having your wellness physical and get asked about every 10 minutes, do you have throw rugs on the ground? The concept is nice, but you guys can figure it out after a while. Someone tells you once not to do it, okay, I won't do it, I don't want to fall. But these checklists seem to appear from everywhere. As everyone knows, when it comes to medications and tests, the prices have gotten to the point where the people who are paying for it, or who are directly paying for it, you paid for it originally, the insurance companies get their hand in what particular tests you may have done. Now the costs, we don't have to talk about how much higher they are. They're paid by insurance, or God forbid, if insurance doesn't come into place with that house that he's trying to protect you from losing. And like I said, as opposed to you and your doctor being who you interact with, now everyone's telling you what to do. You have the internet. Dr. Google is the bane of every doctor's existence. There are some other doctors like that, Dr. Instagram and Dr. Facebook. You have friends who are telling you, your doctor doesn't know what you're doing. Suffice it to say, everyone is talking to you. There are some great things that have happened in medicine over the last 50 years. How we administer it is probably not one of them. So how do you deal with all this? I also forgot to say in the first one, people, when they got to the last years of their life, they often moved in with a family, their children, maybe their grandchildren, they stayed with the family. Now in your final years, you might stay at home with a lot of help. You might move to senior living, which is basically staying at home but having an ergonomically better home. If you need more help, you might end out in assisted living, facilities, like nice places like this, which assist with some of the things that you don't have to do them anymore. From plowing the driveway to cooking meals. When your abilities get to the point where you need help 24 hours a day, that's where skilled nursing comes in. So things have changed a hell of a lot. This ends out, like Attorney Bickford said, which everyone should figure out before they become ill. You see, I picked agent and proxy, and you're saying I picked, both of them are wrong. It should be a health.
Under the statute, it's healthcare representative, but it's the same concept, right?
Pick a healthcare representative who knows your wishes. From my end, I've had, doctors will tell stories, and I won't go too crazy, but stories where they picked a family member, and since I'm the youngest child, I always complain, they'll pick the oldest child. They never pick the youngest child. Just because they're the oldest child, so they're more mature. And then they get to a point where they can't answer for themselves, and things are done that weren't what you planned for. And you might still have a spouse who's trying to tell everyone that. And you might have other relatives who are telling you, that's not what he wanted this. And the way the system works, the system tells us we have to listen to that person assigned. The importance of that person knowing your wishes, I can't emphasize how much that's important, because the documents are helpful when you're in critical medical situations. The very formal ways Dr. Bifford, or Dr. Well, he's a doctor. He's a JD.
Juris doctor.
You know, it doesn't necessarily fit. Every situation could be very individualized. It's hard to say how far someone is in an illness. Someone who knows your wishes is really important. Tell people if your wishes change over time. I mean, it sounds silly, but you know, you probably have that tough talk initially with your children saying, you know, I gotta talk about when I get near the end of my life and this is what I want done. And then something changes that you didn't necessarily expect. You know, we all have illnesses that appear that may not be what we thought was going to happen, and you may want to change your plan. For God's sakes, tell the person who's going to help you out if you can't answer for yourself. I'm glad you mentioned this because I've lived through this. Please don't pick a committee to make medical decisions for you. In this lovely facility here, there was a lovely person who unfortunately was dying from, I believe it was, if I remember right, it was end-stage heart failure. And their document said, it had to be a supermajority of the 6 living children to make any medical decision. The children lived in 5 different states. And we had to make, because we were at that point where we were looking at the terminal phases of the illness, and we had to do this amazingly elaborate phone call to try to pull it off. I'll tell you, when you land in the emergency room, that's not going to happen.
That's right.
It just isn't going to happen. You know, try to pick that person who, in your family, who you know will honor your wishes, and stick with them and keep talking to them. And once again, like I said, don't pick someone who will not honor your wishes just because they're the oldest or they seem to be the most mature. You know, it's not going to help you out. They asked me to talk briefly about code status. And most of this is self-explanatory, but the one subtle thing to talk about. Do not resuscitate means just what it says. I mean, we saw the football player for the Bills did that, you know, had CPR done in front of millions of people. This is where they push on your chest. They're supposed to push in about that much per compression. It's supposed to be 2 inches. That does get blood to circulate poorly, but some. And that pushing that much does get some air in and out. It's not terribly efficient, but in an emergency situation, that's all you get. When anyone is resuscitated, and if there's any success, they're going to have a tube put into their lungs, and they're going to assist breathing that way. One of the things I always tell folks is, you know, I always reverse this, so please bear with me. I want CPR, but please don't put me on a breathing machine. It doesn't work that way. The two, please understand, the two are connected. If you agree to be resuscitated, these are all the things they're going to do. And yes, in a population at your age, it's going to do some damage. It's going to crack ribs. It's not a pretty thing, but it, you know, in some folks it can save lives. Do not hospitalize is kind of self-explanatory. The only thing to think about is the next question that should be coming out of your caregivers is, well, how aggressive do you want me to be? You know, in a facility like this, I have access to x-rays, ultrasounds, intravenous, obviously oral medications, physical therapy, occupational therapy. There are a lot of things that I can do. And again, in this discussion of terminal illness, would want to do what you'd want to do in that phase of your life. You're at a point where you don't want us to do anything. Don't try to get every last heartbeat. It's okay to understand that. That will be something that would have to be cleared up, because and if the last concept is this concept of comfort measures only, that's really not a technical term. I don't think it is in your world, but it's kind of a euphemism that most medical folks to say that this is essentially what people think of as hospice care. All treatment is geared toward comfort. I got to, back when I had hair and was in medical school, get to visit the Brantford Hospice, which was the first hospice in the United States. And I had a tour of it as a fourth-year medical student, and someone asked the question, well, what happens if someone's breathing gets bad? And they said, well, what you want to do is, what we'll do is we'll probably order some medicine to help out with air hunger, and we use morphine to take away the pain. He said, would you use oxygen? Well, no, we're trying to relieve the comfort. Trying to achieve as much comfort as possible. Well, what if you had a urine infection? Well, we would probably give them morphine and probably give them medicine to give them. I very quickly realized that, if we're going to keep them comfortable, we're going to keep someone comfortable. We don't have to concentrate hard on trying to prolong the 500th UTI in someone where it's not what they wanted and things aren't going to get better. Sometimes that gets, it's tricky for people, particularly for family members, to try to make these decisions because they're always geared toward taking care of things. Sometimes, if you have the ability to tell us to stop doing it. One of the things that always humbles me is when I have a patient tell me, no, I'm not going to have dialysis anymore, and I know that means they're going to pass away in 5 days. But my job is to try to let them do let them control their bodies the way they wanted to. I think I've beaten that to death. Who directs your care? This is always what's fun, because there's 3 scenarios. Who takes care, who directs your care? Who's the person in charge when you're at home? Pretty simple, your primary care provider. Consultants, when decisions have to be made, the final decision maker will usually be your primary care provider. In the hospital, understand, it's the hospitalist or the attending physician. It's not your primary care provider at home. People sometimes get confused with that. Yes, if one of my patients is in the hospital, I could call, I could advise, I could make suggestions, but the hospitalist is going to make, the hospitalist is the final say. Similarly, when you're in a rehab setting, like over there, it's the attending physician here. And yes, I'll take advice from the hospitalist and the primary care provider, but the final say is to be from me when I'm taking care of someone in this facility. Who decides when you move? They wanted me to answer this. First off, when you're at home, you decide whether you're going to move out of your house. Now, you're going to get advice from healthcare people you're going to get health advice from consultants you see, you get advice from family members, your good friend's going to say, get the hell to the emergency room. That's you. When you're in the hospital, it then becomes this poor hospitalist again. Medical school, I still think they try to teach you how to heal someone. They don't try to teach you how to maximize efficiencies in this grand, huge system. Unfortunately, that's part of this world we live with. So the hospitalist will almost always be receiving pressure from the hospital, usually through the social worker, to get you out of the hospital as fast as they can. Sometimes to excess. And it's a battle that all of us try to deal with. When you're trying to deal with, is this too fast? It's the hospitalist you need to deal with. By the same token, people feel that way when they come here. The attending here at the rehab, in the subacute rehab, is the one who technically says when you need to be discharged, but all the pressure comes from the insurance, because the insurance makes it simple. They say, patient can stay there, we're not paying. You know, the thing to remember, whoops, uh-oh, now I did it. Uh-oh, let me try that button. Oh no. Why are you doing this, you stupid thing? Bear with me. You can always fight the transfer, but understand you may have to pay. If people say, you know, you can fight these things, it's an awful position that patients are put in. It's probably very unique to the United States. But you have to be honest with yourself. You know, you realize you have to deal with these folks who are shelling the money out, the insurance folks. I think my thing is starting to fight me, so bear with me while I try to do this. Final thoughts I had for folks. Tell everyone who matters what you want. And I smile and I always say, be selfish about it. You know, it's okay to tell one child, this is what I want, and you tell the other child that, and when they say, no, I don't want you to have that, you can tell them where to go, you know. That's going to be so important to allow you to live your life the way you want to. Write it down on paper and show it to every person. This gentleman does a fine job in writing things down on paper and helping it out. Get the information to your primary care provider. The hospitals will often ask for the information, you know, your living wills, healthcare representatives. I'm getting it now.
You got it.
Okay. It is important not just to have the documents, but to make sure people who have to make the decisions see them. And I have one last thought. Last thought, be a critical thinker, because as I think all of you know, there are plenty of people out there who want to take your money and really could care less about your health. I could talk for hours about that, but when I watch TV and watch how the dietary supplement industry takes billions of dollars out of people's pockets for stuff that has never been proven to do a damn thing, and somehow equate their testimonials to rigorous research and trying to use scientific method and trying to prove that a compound is effective. You know, it's always frustrating when I have that conversation, you know, say, you know, Mrs. Jones, you know, I don't know why you take that juju berry, you know, there's no proof juju berry does a damn thing. I said, well, I take it because GNC said it will make my hair darker. But there's no proof about that. And she'll ask me, is it safe? How the hell do I know if it's safe? You know, no one studied this stuff. And she goes, yeah, but it's all natural. Well, ma'am, it's in this plastic capsule that doesn't look like any piece of fruit I've ever seen before. She said, yeah, but I'm going to do it anyways. So, yeah, think, when someone says this works, it's okay to ask them, what makes you say it works? Where's the proof? And, you know, it's okay to do that to your doctor in the office. I mean, I have plenty of people who ask me, and you know, it's my job to say, okay, you know, I suggest you take lisinopril for high blood pressure, because there's studies that date back 30 years that show that it decreases risk of heart attack and stroke, which are some of the main things we're trying to treat with high blood pressure. And it has some has some kidney protective effects. Be critical, thinkers about this. And that, I'm ready to back it up. I don't know if I got as far as George did, but I hope that helps out.
That was great. Thank you so much. All right, now we're going to move on to Janet Collins. Janet has been a senior living specialist at McLean for 8 years and has worked in the senior living industry for a total of 15 years. Jan's passion is helping seniors and their families make the best decisions when it comes to choosing a life plan community. Jan was a part of the team that moved over 50 residents into this beautiful new building, the Goodrich. Jan, I'm going to give you my microphone because you're hearing a little feedback, I think, from that other one.
Okay.
It's more the computer we found out, actually, believe it or
Oh,
not.
really?
Yeah.
Sorry about that.
No.
Hello. Lots of faces that I've seen that have moved into this building. So following these two gentlemen, I don't have all of that information, but both of them talked about planning. And that is, again, I'm gonna say the same thing. Planning to make a move to a senior living community is a big deal. And I have walked through this with many, many people. So understanding the process of that is big. And I say knowledge is power. So any questions that you have, write them down, continue to write them down, bring them when you go to places to talk about and look at where you're going to move to. You know, what they have for amenities, you know, how the whole process goes. It's a lot to take in. And many of you did it to come in here. The application process is one of the biggest things. McLean is a life plan community, which means there's a financial and medical qualification to come here. It is looking at and working with your primary care physician for seeing if you are appropriate, calling it chronic and stable, to move into a place independent or assisted living. They both work somewhat the same here. The applications look the same for our independent living and assisted living. Assisted living's medicals are a little more deeper than the independent living ones. There's a time frame that goes along with assisted living that's not there for independent living. But looking at the paperwork that you have to do can be somewhat overwhelming. Part of the things that Attorney Bickford spoke about are things that we ask in your application. We want to do what you're looking for when you move in here. So the living will, power of attorney, healthcare representative, all of those things, because when you move in here at whatever independent living through skilled nursing, we want to know that, again, just like that child or whoever, we are following your wishes. So we have those documents as well to be part of that. You become part of this community. But there is a financial piece that looks for assets and income that you will need to spend here to live. And Attorney Bickford talked about, you know, Medicaid and those look backs, and if, you know, we ask for, have you done transfers? Have you done that? You know, different things, so that it looks at that so you have a clean application. We do have a business office that can work with you through that. Our financial piece uses the actuarial table. So they look at how old you are, how long they think you're going to live. Independent living and assisted living is private pay. So Medicaid does not pay for that. So as Attorney Bickford is talking about that, you have to also look at that, knowing that you have, you know, you're keeping money to be able to pay that, but knowing that you can plan to also have Medicaid. So it goes hand in hand, working with him and understanding where you're gonna go, what you're looking to do. We walk through this process with everybody. There's a lot of different pieces that go along with our life plan community. There's month to month or entry fees. So there's a lot that's in here, but we're here to review those things, answer any questions. As you go out and look, it's really important to know that if I can't answer a question for you, that I'm going to find somebody to give me that answer. We work with many different people. People come in with different, you know, they have things completely planned out perfectly. Others are just starting the process, and, you know, we will be suggesting to some people, go find an elder lawyer, talk with these things. You have a financial person. Bring all of those people together to talk about what's in your best interest. And we will work through those things. We talk with financial people, we talk with attorneys, you know, we want to share everything that we have. They look at our paperwork, they're very good to be able to review these things with you. So my suggestion, if anybody here is starting this process, if you're looking for a life plan community, it is different than for-profits. McLean is a not-for-profit, where it's just us, so money does not go to stockholders. You are reinvesting in where you're living, and that's huge to know that here you can live here in independent living and then move up to, if needed, assisted living, skilled nursing. Again, as you're talking about that, your family members, it's peace of mind. You have chosen to come to a community that you know you have whatever you need as you move forward. Your team is here to work with you, talk about those things, and we work with your families as well as you go through this. So our application process is 3 pieces. Like I said, there's a financial piece. There's a medical piece that we work with your doctor with, and then there's a demographic that's just about you. So it all works together. It can be overwhelming when you start this process to come, but I encourage you, anywhere that you go, come and see us, ask questions. That's what we're here for, to help you through this process and not make it too overwhelming. Making the decision to make a move, whether it's you're coming in knowing this is exactly what you want to do, or you're doing it for a spouse that you'll need, will need care maybe before you. It's still overwhelming. So we hope to try and make that, as easy as possible, sharing all the things that we do. Kate and I, Margaret, we work together. McLean is not that big that we don't know, one another and can call each other in to help with different things. So our hope is that getting that piece of it done, you're moving on to the good things of making the plans to move in and that type of thing. But we're here to answer those questions that you have tonight. But going off of these 2, planning, talking to your family, bringing them in to be part of this so they understand what you're doing is huge. You may have some that are agreeing with you, and you may have children saying, no, stay home and do this. It's your plan. Your children are involved, but do it in time where you can make the plan, and that you're not missing, especially for independent living, that you're not missing being able to come in independently, because there is a line that no longer lines up for independent living if you need care. So I would encourage you, if you've got questions, many of you live here, but there are some differences that will happen, if you need to make the change to assisted living. We're all here to answer those questions and learn and teach you what those are. Again, we're around, our team is around, so I encourage you, whether you already live here or you're looking around, come and check us out, come and ask questions. That's why we're here. We're trying to help you make informed decisions and walk through this process with you. So with that, we can do questions.
Yeah, want to jump right into questions? The only thing I just want to, before we jump into questions, I just want to remind everybody, please fill the survey out. You don't have to give us our name, but one of the reasons why I was mentioning that is our next McLean and Me series, or our next month, we're going to do levels of care in a life plan community. But after that, in March, we're doing a deep dive into memory care, and that directly came from the surveys. Our first McLean and Me was memory care. People filled it out and said, I want to know more. My loved one has dementia, but now what do I do? So that's a direct result of that survey. So that was really great feedback. So any kind of feedback that you can give us would be great. And with that, we'll jump into questions. Who's got the first question? Okay. If you can speak as loudly as you can, and then and tell us who the question is for, and then we'll give the microphone over.
My question is directly to Victor. Where does the Connecticut Partnership Long-Term Care Insurance fit in with the assets?
Good question. She said, where does the Connecticut Partnership for Long-Term Care fit into this equation and what we were talking about? If I had more time, we would have gone over that as well. It's very important. As a matter of fact, people go out and purchase long-term care policies that will pay for home care, assisted living, or what they call an alternate plan of care, or skilled nursing care. And those policies can be diverse, all kinds of different policies. However, there are certain policies, and I think there's only 9 companies right now in the state of Connecticut that are certified by the Connecticut Partnership for Long-Term Care. The Connecticut Partnership for Long-Term Care was set up by the legislature. It was done through the Office of Budget Management, I believe, and Office of Management of the Budget. And in order for a company to be certified, they have to meet certain requirements. And they can sell a policy that says this is certified by the Connecticut Partnership for Long-Term Care. That policy is actually much better than your typical long-term care policies, because the Connecticut Partnership says that if you buy this policy and it pays for your care, and then you run out of money, and then you want to apply for Medicaid, Medicaid will allow you to keep your assets to the extent of what the policy paid. So Medicaid would normally only allow me to keep $1,600. However, if I had a partnership policy and it paid for my nursing home care, and let's say I had a policy that paid for 3 years, and after 3 years, this policy paid out, oh God, $270,000, okay? Over the 3-year period. At the end of that 3-year period, the policy stops paying because it's expired. Now, when it expires, then I apply for Medicaid. They're gonna let me keep $270,000 plus $1,600. Not bad, huh? So I can still get Medicaid and still have $270,000 that I can preserve and protect for my heirs, right? Also, I can protect for my spouse. So if it's a husband and wife, and you both have a partnership policy, and one of you goes in, policy pays for your care. When it expires, your spouse applies for Medicaid. And if she's only allowed to keep $148,000, but my policy paid for $270,000, they're gonna let her keep $470 plus 48, $418,000 instead of $148,000. So it's an asset protection mechanism. It's an incentive for you to buy these policies so that if it pays for your care, the state doesn't have to pay. And if it stops paying for your care, the state says, since you were a good puppy and you bought this policy, we're gonna let you keep dollar for dollar what the policy paid. They're a good piece of the puzzle. And if you have a financial advisor who deals in the insurance industry, generally you want somebody who's an independent agent who can shop around for you. They can tell you what the cost of those things would be. Now, you don't need something that's gonna pay the entire cost of the nursing home. You just wanna make sure that you figure out, if I go to a nursing home, it's probably gonna cost me $15,000 a month. So if I go to a skilled nursing facility and it costs me $15,500 a day, I don't need a policy that pays $500 a day. I figure the cost, I subtract my income from that, and then I insure for the deficit. So if I have $5,000 a month in income between Social Security and pension, and I'm gonna have a $15,000 a month cost, then I need a policy that will pay $10,000 a month for my care. So between my income and the policy, it'll cover the cost of my care without depleting my principal. And at the end of that period, whether it's a 2 or 3 or 5 year policy, when that period is over, if you're still alive and you run out of money, you can keep dollar for dollar what the policy paid. So it's a good piece of the planning, okay? Did I answer your question okay? Thank you.
There you go. Next question, any other questions? No questions? Okay.
Can I make one comment?
Yes, please.
One of the things that Dr. Bleekus mentioned I wanted to comment on is he said people need to know what your wishes are. And that should be your entire team. Your financial advisor, your accountant, your doctor, your lawyer, your kids, your spouse. In addition, when we do a living will for somebody, which I said that's a layman's term, but we do a living will and healthcare representative, we ask him in our checklist, who's your primary care physician? And we get the name, address, and telephone number of the primary care physician. And I'm sure Dr. Bleekus has gotten some of mine in the mail. Living wills, signed by the client. We send a copy to the doctor and ask him to make it part of my permanent medical records. And of course, I get clients who say, well, what happens if I change doctors? Well, your records go with you to the new doctor, you know? And of course, nowadays, it's almost all digital, so they can give you a thumb drive or a disc, and boom, you take it to the new doctor. But the key is this, make sure people know what your wishes are. Because when he talked about that, it reminded me of a case I had not too long ago, where I had a gentleman come into my office,
and he was worried about his father. He says, father's having serious problems, he had a stroke, it's affected his cognitive functions and his memory, and so I asked him, do you have these things in place? No power of attorney, no living will, no will. He said, my father was a very private person. He refused to disclose any information. And if I ever asked him anything, he would say to me, you'll find out when I'm gone, okay? Well, no, I'm not gonna find out, because this kid was telling me I have no idea what he has. I don't know if he has an IRA. I don't know if he has stocks or bonds or mutual funds. So my comment to him is, you better go through his mail and his records and try to piece together what he has. And if dad's not competent to sign a power of attorney at this point, we end up going to the probate court to become conservator so the son can manage his affairs. Don't wait until it's too late. Don't be a stubborn old cuss. And I am a stubborn old cuss, but I still know the benefit of planning and keeping the people who I care about and who are my providers and my team in the loop. And as he said, if I change my mind, I gotta tell them, okay?
Is that the most common mistake or pitfall that you see people make, or is there a different one?
Well, the most common mistake I see is people don't plan ahead. They just don't plan. And if they don't plan and they don't have these things in place, we're stuck if you're incompetent now. So you wanna do these things while you're of sound mind, and you got your wits about you, you know what your wishes are, get things in place. Consult with an elder law attorney.
I gotta say, the challenge that I will get is the proverbial family member who comes in from California, who has not dealt with the day-to-day care of the loved one, and then someone lands in a critical situation in the hospital, and the proverbial relative from California comes in and says, I know what to do. Everyone's not, you can't do this, and then we'll try to browbeat the healthcare team to try to force them to do what they wish. Those are the scenarios where if the doctor has the document, you can smile and go, ma'am or sir, I have to do what this says, or else Attorney Bickford will take my money, and I like my money. You know, that's the defense. You know, without the documentation, these can turn, particularly in hospital settings, into shouting matches or who's the most scariest family member, and that's not the way you want. That's not how you want your health care determined.
And I hate to hear it when the kid says to me, I know what my mother wants. I'm like, oh, Jesus. No. How do you know what your mother wants? Well, she told me. Well, mom's not competent now to tell us that. She's got no documents in place. You don't have the legal authority to speak for her. You don't have the legal authority to make health care decisions. And I'll get a kid calling up and saying, well, I want to be involved. And I said, well, you know, your mom didn't want you to be involved, and she named other people to handle her affairs. Well, I want copies of her documents. Well, you have no legal authority to get those documents. They're confidential. If you want the documents, talk to mom. Tell her you want a copy, and mom can tell you to take a hike, okay? I'm not revealing any information about a client without my client's consent, okay? And that's very important. So that's when we have that.
You do that too, huh? You guys do that too.
Yeah, absolutely.
Yeah, we do the same
Well,
thing.
if you called my office and said, is Mr. Smith your client? I'd say to you, what's your name, sir? And I get your name and telephone number. So let me check and I'll call you back. Then I call Mr. Smith, if he is my client, and say, I got a call from Harry Jones, and he wants to know if you're my client. Do you want me talking to this guy? He goes, I don't even know who the hell that is. Fine. So we don't call him back, okay? Or we call him back and say, I can't give you any confidential information. But if somebody calls me and then I call my client, the client says, well, yeah, I talked to Harry and I told him to call you because he's going to help me with some financial issues and I want you to be able to speak to him. Fine. Then I call Harry back and say, okay, what's up? But I can't even reveal that you're my client without your consent, okay? So it's very important, just like confidential medical information, legal information is confidential as well. And it really bugs me when I get the kid who has no involvement, who says, I know what my father wants or my mother wants or what her wishes are. It's just so frustrating.
They're from California.
Yeah, especially.
Always from California.
Well, thank you very much. Great, another question.
This is for Dr. Polikas. Doctor, we're aware as residents here in Goodrich that there is health care available for independent living residents. Could you give a little quick synopsis of what's available?
She was asking about what healthcare options are available here for people who live in the Goodrich or other areas. There are two organizations that have ability to take care of you here. Our group, Prime Healthcare, is myself and Holly Smith, API PRN who I work with. I do have some office hours here in the facility. They gave me a nice office. They keep taking stuff away from, I have to talk to you guys about it. Actually, I got mad because they took my desk away. I said, I have to have a desk. But I will see some people there. It's a different model because Holly Smith is here, admittedly, I think she's here 4 days a week routinely for 4 to 6 hours. She has the capability to be able to see people and follow through a problem far more thoroughly than you could ever get in my office practice in Wethersfield. You know, it's just, she will often see someone because they have a problem. Maybe they have a heart problem and they're drifting into heart failure. She will make adjustments in the medications, but we'll follow up 2 days later and 5 days later. Do the kind of things that the nursing reports would have given her if you were in the hospital. I'm there often to help out when the few times she needs help with a confusing problem, sometimes she'll come to me. Sometimes we'll do things together with caring for certain patients. I'll admit it's not the traditional Dr. Kildare version. UConn with Dr. Costello she's now having more hours in this facility. Dr. Costello is a UConn geriatric medicine physician. And basically I'm having her spend more hours in this facility. So I think she has office hours, I think at least once a week. I don't know if that would be a more traditional kind of, well, I see my doctor, I see him or her in the office. You know, I can't talk too much more. I don't know more of the details about her practice, but that's what's here at this point.
You mentioned
What?
she's connected to UConn. Are you connected to UConn also?
No, I'm not. I'm a dinosaur. Prime Healthcare is one of the last physician-owned large medical groups left in Connecticut. So technically, I don't listen to anybody. So you know, I mean, my affiliation's been with St. Francis for a long time. I did my residency there in the 80s, and then I was an attending physician in the years when I used to go to the hospital. And I stopped going to the hospital about 10 years ago. Having said that, my office is in Wethersfield. You know, I can throw a rock and hit Hartford Hospital before I can hit St. Francis. And so I have relationships with a lot of Hartford Hospital consultants, specialists, and subspecialists. It allows me to, more than I could ever working for a particular hospital, have people see who they wish, or just tell them, you know, when it comes to this, why don't you go to Hartford Hospital? Let me point you toward this person, or it might be St. Francis. Or every now and then it's UConn. I have a little bit more, that's the one thing about my model that I have a little bit more latitude with than someone, you know, Dr. Costello is excellent and honorable, but she does work for UConn, and, you know, they will expect her to refer to UConn.
Thank
What if you were to refuse to go to UConn?
Remember, you always get the final say. Oh yeah, you could look at her and say, you know, I like you here, but, you know, if I get sick, send me to Hartford Hospital as soon as you can. No, that's not a problem with her. Her bosses won't like it, but she can manage it fine.
Okay, any other questions? Oh, okay.
Well, maybe it's doctor one. I know even if you have all your documents, we all don't travel with them in our back pocket. So if a loved one or a dependent lands in the hospital, how do they know, hey, I'm the one, I'm their health care? Do they check something? Because like I said, my stuff's gonna be home in a drawer. Because we don't travel with all those legal documents on our hands at all times.
So the question is, when your loved one lands in the hospital, who the hell knows where the documents are?
Right.
The hospital.
Because you sign them and you tuck
Right,
them
you-
away, like we probably all do in a nice drawer.
The hospitals in their wonderful electronic medical records do a fairly good job of collecting that information and having it there so that they know. As you said, I have a number of patients who in their records, they've given me their healthcare representative documentation, and I'll have it in there. A lot of times, though, it will be a social worker at the hospital will do the digging.
Okay, all right. Is that whole Epic thing that's all online?
Oh, yes, yes.
Okay, all right.
If you say Epic again, I might have to leave. You have to forgive me, I get my Epic through St. Francis, and St. Francis has decided to upgrade Epic.
Oh, yeah.
So get your health care in before the last week in March. There will be a week or two where people affiliated with St. Francis will be cursing the gods again.
Okay, I'm just always curious because like I said, I don't think any of us in the room have it right available. And somebody's gonna do something to save the person before they.
So, that scenario would be if the physician's sitting there going, I have to make some decisions, and this patient is not able to do it. They'll likely first talk to family members who are in the room. It's probably the one dangerous thing that doctors do, because you're kind of trusting them to be honest. And, I guess there's always the possibility that that relative from California says, oh yeah, I know, I have the document. But most folks are honest about that. And then it might be the social worker trying to reach out to the particular family member, or it could be sometimes it's the lawyer's office to get the information.
Oh, that answers, thank you. I don't have any relatives in California.
Sorry, if you're from California, I apologize.
No, so.
Okay, we have another question in the back.
So for Dr. Bickford, say you're trying to, your time, consider putting your spouse into assisted living or, Title 19 or something like that going forward. But you have two homes, like you have a summer home, your primary home, and they're both in both names. And do you have to get rid of one, or how do you shield that, or what can you do?
Well, first of all, the second home will be a countable asset. So if my spouse can keep my home, plus car, plus personal property, plus her income, plus 148,000, anything over that is a countable asset, including the second home, the summer home, whatever. Now, what I tell people who are retiring or moving on in life and are concerned about those kinds of asset protections, if you needed long-term care and you own two pieces of property, in order to get Medicaid to provide you care, we would have to list that second property for sale. As long as it was listed for sale, Medicaid would help you. But then once it gets sold, then we'd have to do something with those assets to pay for your care, unless we can put them into an annuity for your wife. But the key is the second home is countable, right? Now, many times I get clients like you who have two pieces of property, and they take the summer home or whatever, and they say, this is gonna stay in the family. I have no intention of selling it. Good. We put it in the kids' names. We keep a life use for the parents. As long as you make 5 years in one day, that place is protected. I had somebody do this with a piece of property in Charleston, Rhode Island, that was appraised at over $1 million. And they did this more than 5 years ago, kept a life use. So they get to choose when to use it. They're still responsible for the taxes, the insurance, the maintenance, and the upkeep. They determine who goes there and when, because even though it's in the kids' names because of their life use, the kids can't say, we're taking this week. No, that's our week, okay? So the parent still controls, but the title or the equity in the property is in the kids' names, subject to the parent's life use. That's something that can be done with some advanced planning. But if you don't plan ahead and you have two pieces of property, one of them is going to be countable and may have to be liquidated to pay for care.
Thank you.
We all set?
Are we good? All right. Oh, go ahead.
Just wondering for DNR and not hospitalized, when do you recommend that people sign that? Is it just when you go into skilled, or do you need to do that when you come into independent living, or you're 50 years old and you should do it out? You should then be filled out.
People should know your wishes now. I tell my wife I'm going to linger, so you keep me going. But I'm in relatively good health. I do have some chronic illnesses that it has actually made me have to think about this for myself. But basically, at any given time, we all need to have in the back of our heads what we want to do. Also remember, if no one speaks up, the physician is obligated to do everything possible. But answer your question, I mean, when we're 25 and healthy as a horse, we should sit there and say, yeah, no, I want everything done. Or if I was permanently unconscious, or what's the word, I never get the wording right, that maybe that would be the one scenario where I'd want you to withhold care. It's a good example of how this just changed throughout your lifetime.
I'd like to make a comment on that. I had a client whose husband was terminally ill at home. She was caring for him, and he had a crisis, and she called 911. And when they showed up, they came to get her husband to bring him to the hospital, and she said he has a living will and he doesn't want to be resuscitated. Well, I don't care how many living wills you have. You can plaster them all over the house. You can keep them in your pocket. You can give them to the ambulance driver. They must resuscitate you if you call 911, unless you have a DNR bracelet, okay? Now, that is issued by the health department, and it has to be prescribed through your doctor. And it's like a medic alert bracelet, you know, like for people with diabetic or hemophiliac, and you wear that bracelet, and if my wife has that bracelet, and I call 911 because she's collapsed, they come in, and I can show them that bracelet, and they're not gonna resuscitate her, okay? But that's the only time that it's a blanket do not resuscitate. Now, if I'm in the hospital and I sign a DNR order, that controls for the hospital. If I go to my doctor and I give a DNR order, he knows what my wishes are. But if I call 911, they have to give me CPR unless I have that bracelet, okay?
Why have a DNR then?
Well, there's no reason not to have a DNR if you want one, but you have to do it properly. In other words, living will only applies if you're institutionalized. You know, if I go to the hospital and they say, well, what's his wishes? Here it is, okay?
Right.
And DNR is two different things. If my living will says, I don't want CPR, cardiopulmonary resuscitation, that is only if I'm dying. In other words, if I'm in the end stages of a terminal illness, permanent coma, or persistent vegetative state. If there's a chance of saving me, I want them to resuscitate me, okay? But if I'm 85 years old and I've got Parkinson's disease and my quality of life is crap, I might say I want that bracelet, because I don't want them to resuscitate me under any circumstances, okay? But if you don't have it, you call 911, they have to resuscitate you.
Is that just Connecticut?
That's Connecticut law. That's Connecticut law, yes.
Okay, well, thank you so much, everybody, for coming out, and I certainly want to thank Attorney Bickford, Dr. Palikis, and Janet. Give them a round of applause. I think they did a wonderful job. Thank you so much.